A significant development in United States immigration policy has emerged this month, and it carries profound implications for thousands of skilled professionals seeking permanent residency through the employment-based second preference category. Immigration attorneys across the nation are issuing urgent advisories to their clients, warning that the current window of opportunity may close as early as next month. For those who have spent years navigating the complexities of the American immigration system, the March Visa Bulletin represents what many are calling a pivotal moment that demands immediate attention and decisive action. The Department of State has officially released the March Visa Bulletin, revealing that the dates for filing chart for the employment-based second preference category has reached current status for applicants from most countries outside India and China. This designation carries extraordinary significance within immigration law circles. When a category achieves current status under the dates for filing chart, and when United States Citizenship and Immigration Services confirms that adjustment of status applicants may utilize that chart during the relevant month, it effectively opens the door for eligible individuals physically present in the country to pursue their green card applications without further delay. Immigration experts are characterizing this development as both remarkable and precarious. The employment-based second preference category has historically experienced substantial backlogs, unpredictable movement patterns, and periodic retrogression that has left countless qualified professionals in prolonged uncertainty. Advanced degree holders, researchers contributing to critical scientific endeavors, engineers driving technological innovation, healthcare professionals serving communities across America, and individuals pursuing national interest waivers have all faced the frustration of watching priority dates inch forward at an agonizingly slow pace. The current situation presents these applicants with a rare alignment of favorable conditions. However, immigration analysts are cautioning that this window could narrow dramatically when the April Visa Bulletin is released. Historical patterns strongly suggest that when a high-demand category suddenly becomes current after extended periods of backlog, the resulting surge in applications frequently triggers swift retrogression. Understanding the mechanics behind this phenomenon requires examining how visa number allocation functions within the federal immigration system. The government operates on a fiscal year that spans from October through September, with employment-based immigrant visas distributed according to category and country of chargeability. When demand remains lower than anticipated during the early months of the fiscal year, the Department of State may advance cutoff dates or establish current status to encourage utilization of available visa numbers. Conversely, when applications flood the system, authorities must implement new restrictions to prevent exceeding statutory annual limits. This dynamic creates the present urgency. If thousands of employment-based second preference applicants submit their adjustment of status applications during March, federal agencies may determine that visa demand for the remainder of the fiscal year has been fully allocated. Such a determination would likely result in the imposition of new cutoff dates in April, effectively closing the door for those who failed to act during the current window. For individuals presently maintaining lawful non-immigrant status within the United States, the implications of this development extend far beyond mere paperwork. Filing for adjustment of status while a category remains current unlocks several critical benefits that can fundamentally transform an applicant's immigration posture. Upon proper submission of the Form Y-485, applicants become eligible to seek employment authorization and advance parole travel documentation. This combination provides something that many skilled immigrants have long sought but rarely obtained: genuine flexibility and stability. The employment authorization document issued in connection with a pending adjustment of status application is not tied to any specific employer. This represents a dramatic departure from the constraints imposed by employer-sponsored non-immigrant classifications such as the H-1B visa. Similarly, advance parole authorization permits travel outside the United States without abandoning the pending green card application, eliminating the anxiety that has accompanied international trips for so many professionals bound by restrictive visa conditions. Immigration advocates emphasize that these benefits materialize only when applicants file during periods of current status. Once retrogression occurs, the opportunity to obtain these protections vanishes, and applicants must resume waiting for their priority dates to become current again under potentially less favorable conditions. The employment-based second preference category encompasses two primary pathways to permanent residency. The first involves individuals who possess advanced degrees or who can demonstrate qualifications equivalent to such credentials through a combination of education and professional experience. The second pathway serves individuals who exhibit exceptional ability in the sciences, arts, or business, evidenced by a record of achievement substantially above that ordinarily encountered in their respective fields. Many applicants pursue employment-based second preference classification through traditional employer sponsorship, a process that typically requires completion of labor certification proceedings before the Department of Labor. This pathway involves the sponsoring employer demonstrating that no qualified American workers are available to fill the position being offered to the foreign national beneficiary. Alternatively, the National Interest Waiver provides a self-petitioning option for individuals whose proposed endeavors carry substantial merit and national importance. This pathway has gained considerable attention in recent years, particularly among researchers, entrepreneurs, and professionals whose work advances American interests in technology, healthcare, environmental sustainability, and other critical sectors. Regardless of which pathway an applicant has pursued, the current status of the dates for filing chart creates an extraordinary opportunity. Those with already approved Form I-140 immigrant petitions may now proceed directly to adjustment of status filing. Those whose petitions remain pending or not yet filed may explore concurrent filing, submitting both the immigrant petition and adjustment of status application simultaneously. Concurrent filing offers substantial advantages for eligible applicants. Rather than waiting potentially months or years for immigrant petition adjudication before taking the next step, applicants can set the entire process in motion at once. This approach can accelerate access to employment authorization and travel permission, providing earlier relief from the constraints of non-immigrant status. Immigration attorneys are urging their clients to approach this opportunity with both urgency and precision. The anticipated surge in filings during March may strain processing capacity at service centers, making accuracy and completeness more critical than ever. Applications containing errors, omissions, or improper fee payments risk rejection, which could prove devastating if the category retrogresses before a corrected submission can be filed. Maintenance of lawful status represents another essential consideration. To qualify for adjustment of status, applicants generally must be maintaining valid non-immigrant status at the time of filing, subject to limited exceptions. Those whose status expiration dates fall within March must ensure their applications reach the appropriate service center before that deadline passes. Filing after falling out of status could create eligibility complications that might otherwise have been avoided. The current development carries particular significance for certain categories of non-immigrants facing imminent status-related challenges. International students maintaining F1 status, especially those whose optional practical training authorization periods are approaching expiration, may find in this opportunity a critical lifeline. Filing adjustment of status while still in lawful status could provide a pathway to employment authorization that continues beyond the optional practical training period, offering continuity that would otherwise require alternative arrangements. Similarly, H-1B visa holders approaching the 6-year maximum duration of that classification may discover in this moment a means of securing their position within the United States. While certain provisions permit H-1B extensions beyond 6 years under specific circumstances, a pending adjustment of status application provides additional security and flexibility that can prove invaluable during periods of uncertainty. Family members of eligible applicants should also recognize the scope of this opportunity. Derivative beneficiaries, including spouses and unmarried children under 21 years of age, may file their own adjustment of status applications alongside the principal applicant. This means entire families can move forward together, with each member potentially obtaining independent employment authorization and travel permission while their cases remain pending. The emotional dimensions of this situation deserve acknowledgement alongside the technical details. Countless skilled immigrants have invested years building lives within American communities. They have established careers, purchased homes, enrolled children in schools, and contributed meaningfully to research institutions, healthcare systems, technology companies, and entrepreneurial ventures. Throughout this time, the uncertainty of temporary immigration status has cast a persistent shadow over their achievements. Every visa renewal has carried risk. Every international journey has required meticulous planning and considerable anxiety. Every contemplated job change has demanded careful analysis of potential immigration consequences. The psychological burden of this prolonged uncertainty extracts a toll that statistics and policy documents cannot capture. When a category becomes current, it offers more than administrative convenience. It offers the prospect of relief from constant worry. It offers a step toward the permanence that enables genuine long-term planning. It offers validation that years of patience and compliance have brought the applicant closer to resolution. However, this relief remains contingent upon action. The present opportunity demands prompt response from those who wish to benefit from it. Immigration professionals are advising clients to undertake several critical steps immediately. First, applicants must confirm that United States Citizenship and Immigration Services has officially announced the use of the dates for filing chart for adjustment of status applications during March. This confirmation, typically published on the agency website, represents the key that unlocks filing eligibility under current conditions. Second, applicants must verify their own eligibility by examining their priority dates, countries of chargeability, and current immigration status. Errors in this analysis could result in improperly filed applications and wasted opportunities. Third, applicants must prepare comprehensive filing packages that include all required forms, supporting documentation, photographs, medical examinations, and filing fees. Given the anticipated volume of submissions during March, service centers may process rejections more quickly than acceptances, making thoroughness essential. Fourth, applicants must ensure timely submission before any potential change in bulletin conditions. While the April visa bulletin typically becomes available in mid-March, providing advance notice of the following month's cutoff dates, relying on last-minute filings creates unnecessary risk. The distinction between the dates for filing chart and the final action dates chart merits clarification for those less familiar with immigration terminology. The final action dates chart indicates when visa numbers actually become available for final adjudication and green card issuance. The dates for filing chart indicates when applicants may submit adjustment of status applications to enter the queue, even if final action must await later visa number availability. When United States Citizenship and Immigration Services authorizes use of the dates for filing chart, it expands the pool of individuals who may file adjustment applications during that month. This authorization does not guarantee immediate green card approval, but does secure the applicant's place in the processing queue and triggers eligibility for employment authorization and travel permission. The present situation reflects the use of the dates for filing chart for employment-based second preference applicants from countries other than India and China. Those from India and China face different cutoff dates due to per-country limitations that have created substantial backlogs for nationals of those nations. For applicants outside the United States, different considerations apply. Consular processing timelines and procedures vary, and the focus of the current advisory centers primarily on those physically present within American borders who can pursue adjustment of status. Historical precedent strongly supports the concerns being raised by immigration experts regarding potential April retrogression. Multiple employment-based categories have experienced patterns of rapid advancement, followed by sharp pullbacks when demand exceeded expectations. These reversals have occurred with little warning, leaving applicants who delayed mere weeks or days unable to file applications they had assumed would remain available. The phrase alerting applicants to act now is not intended to induce panic, but rather to communicate urgency grounded in documented patterns. Those who have followed employment-based immigration developments over recent years understand that opportunities of this nature can evaporate quickly. Professionals who have invested considerable effort reaching this point in their immigration journeys should recognize March as potentially their moment of breakthrough. Years of maintaining complex visa statuses, accumulating documentation, and monitoring bulletin movements have led to this juncture. The alignment of current status, chart authorization, and physical presence within the United States creates conditions that may not recur for an extended period if retrogression materializes. Consultation with qualified immigration counsel remains essential. Individual circumstances vary, and the general principles discussed here cannot substitute for personalized legal analysis. However, the overarching message transcends individual case variations. The employment-based second preference category presents unusual opportunity in March, and that opportunity faces substantial risk of disappearing in April. For those who qualify, this is the moment to transform eligibility into action. Because if the next bulletin brings retrogression, the wait resumes, and no one can predict when comparable conditions might return.